This video is going to do a quick spotlight on a modern civil rights issue, and that is that involving affirmative action. So, we talked about this earlier in the year, but if you have sort of forgotten, affirmative action is any kind of policy that is used to support members of a group that has suffered historically from discrimination. This could be African Americans, it could be women, it could be any group in the minority that has been denied equal access or opportunity. So affirmative action is has been used on many fronts, but the area that has been like the most focal or a focal point of it has been that of college admissions. That's where we've seen the most action with Supreme Court decisions regarding affirmative action policies. So the Supreme Court has a long, complicated history with affirmative action and colleges using it in the admissions process. So the first case they look at is the case of California versus Bakke in 1972, and this is the University of California. So basically, what this involved was the University of California's admission program allowed what were called like racial quotas, right? So they basically had a designated amount of their incoming class that was set aside or reserved for members of each racial or ethnic group. So, for example, 10% of the incoming students have to be African American. The Supreme Court was very uncomfortable with the University of California's use of racial quotas. So they basically struck this down, this admissions policy, as being discriminatory. So they actually said that California's policy was not okay, the use of quotas. But what they did also say in their decision was that they were okay in the future if race was a small component of many that was used by a university to decide who's getting admitted to the university. So in this case, they felt like quotas were too much reliance on race, but they were leaving the door open to potentially allowing colleges in the future to craft an admissions system that would consider race to be a small component. But what this means is that ultimately they set themselves up for a never ending stream of cases in which individuals were arguing that race was too much of a factor in their college's admissions policies because it doesn't really define what a small component is. So there are two significant cases in 2003. They look kind of similar. Bollinger is the president of the University of Michigan. The first case, the Grutter case, is a student in the law school that's alleging that their school is too reliant on race. Minorities are being given too much preferential consideration in the law school's admissions policies, and that's putting other students at a disadvantage. And the Supreme Court very much disagreed. They looked at the law school admissions policies and were comfortable that race was only a small piece of the puzzle that was being considered. So they allowed the law school policies to stand. But like they struck down the undergrad policies that were involved in the Gratz case. Roughly, this involved the University of Michigan's undergrad system, where students would accumulate points through like satisfying a variety of factors. 100 points would basically get you in to the university if you accumulated them during the college admissions process, and 20 points, 20% of the overall admission policy was given to minority applicants if they were from a disadvantaged or underrepresented racial or ethnic minority group. So, in the eyes of the Supreme Court, this was too much reliant on race. So, they struck these policies down. So, it's like a case by case decision until 2023. In a case involving Harvard University, the case was called Students for Fair Admission versus Harvard. The Supreme Court changed its policy and decided that they no longer felt comfortable that race should be taken into consideration at all. So, affirmative action, essentially in the college admissions process, was ended by this case, and that applications now are racially blind, racially neutral, and that race cannot be taken into consideration even if the intention is to benefit a minority group member.